Hello, everyone, and thank you so much for joining us for our fourth and final installment of BFSG Summer Webinar Series. Today on estate planning and how to help secure your legacy. With that, let me hand it over to Paul for introductions.
Hi, everyone. My name is Paul Horn, Director of Financial Planning here with Benefit Financial Services Group. In my role, I get to talk about everybody's two favorite topics, death and taxes. Today, we'll be covering that first one. Very happy to have Kara with us here. Kara is kind of like the expert to the experts. So although I do a lot of estate planning with clients in the financial planning space, if there's any complexities or things that I have questions with, Kara is the first resource that I typically will use. So thanks so much for joining us, Kara.
Absolutely. Chad, Paul, thank you for including me in today's discussion. As both Paul and Chad mentioned, I am an estate planning attorney. I practiced for many, many, many years in South Florida. And then several years ago, I left private practice to join Focus Financial, the parent company for BFSG. And I provide estate planning advice to the advisors. So I'm always a resource available to them to help with any questions they have on estate planning matters. Now, my few disclaimers that I have to give before I start, which is while I am a former practicing estate planning attorney, I am not your attorney and I am not here to provide any legal advice or counsel. I am here to educate you on estate planning matters, but you most definitely should consult your financial advisor and your own attorney with regard to your own specific needs and estate plan. Two other minor things I just want to mention. This webinar is to discuss the basics of estate planning. It is not going to discuss where your assets should go when you pass away or who you should leave them to, nor is it going to discuss really whether assets should remain in trust or outright or how you want to distribute everything when you pass away. Those are important discussions, and I definitely recommend discussing those with Paul and your financial advisor. But today we're going to talk about the broad strokes.
Perfect. Chad, why don't you kick us off with the first poll?
I love it. So just as you know, just to get a kind of gauge for where everybody on the line, right, with the several hundred people tuning in today from across the country, what documentation do you already have that might let Kara and Paul kind of customize a few of their comments throughout today's presentation? Do you have beneficiary designations set up for either health insurance, 401k, 403b, 47, et cetera, guardian designations, power of attorney, will, trust, maybe none of it. The state can figure it out. I hope that's not the answer. But we do have a few people saying that already. And I think Kara's comments today, well, she's not going to tell you where to put your specific assets. She will talk about the process and what actually happens if you do leave it there. And then the last one, this is all in another language. That's why I'm tuning in today. I'm going to leave this thing up for just a few more moments as we gather a few more responses seem to be coming in, and then I will share responses with the group as always so we have an idea what came. And again, this is not a pick the one option. It's you can have many of these, so definitely select all that apply as you complete the survey. Okay, let me close polling. We have most people have responded, and I'll share results with the group here. And I'd love to see over 70 people already have beneficiary designations. For the other, almost 30% of you, definitely go fill those out. That's the easiest place to start with estate planning.
For sure.
13% have guardian designations, 27% have powers of attorney for healthcare property, 31% have a will, 26% with a trust, 13% are in that bucket. I said the state can figure it out. So it's a very costly proposition, but if that's what you want to do, so be it. And then we have 6% of people saying it's all in other language. We're hoping that this can help us out. Let me stop sharing results and I'll give it back to you to kick this thing off.
So that's actually very helpful to know where we are and where to begin. So why does estate planning matter? As Chad mentioned, the state could figure it out, but the state isn't going to figure it all out under any circumstance. We want to ensure that your assets go to whom you want them to go to. We want to protect and control assets and have someone to make decisions for you, both financial and healthcare, if you become incapacitated. You want to clearly communicate your wishes to minimize confusion and avoid fighting amongst loved ones, which unfortunately we see all the time. If you have minor children, it's important to have an estate plan in place in order to appoint a guardian if something happens to both parents. And then last but not least, with regard to the state, we also want to do some tax planning for those where that is important. So we'd rather protect what goes to your loved ones and your beneficiaries rather than it going to Uncle Sam.
Yeah, and the point of this today, you can be 18, you could be age 100. There's going to be some level of estate planning you're going to want to get done no matter where you at in your life spectrum. We all are in different chapters, but it's just important to know, and we'll talk about with each chapter in your life, kind of what documents you should be considering. And this isn't something I recommend waiting on, especially if there's little kids. If there's one thing you take from today, definitely get the guardianship paperwork. Nothing worse than minors losing their parents. And it's even worse when relatives start fighting and going to court to figure out who's going to raise them. So I would definitely start there. I have had clients pass away prematurely. We all have stories of friends or family members that have died prematurely in our lives. I had one client that we did a financial plan for. We were just finishing the financial plan and diagnosed with cancer less than 6 months to live. So luckily they were working on the financial plan. So we were able to get their estate planning done just before he passed. But man, cancer's a nasty thing, and things like that unfortunately do happen. So it's why we want to have this plan in place.
Most definitely. Chad, to go back to your survey, I think 31% of those who responded said they have a last will. And the last will is important, and lots of people think I have a last will, I am set. But in reality, the last will is sort of the end, it's the last document we need to consider. And as Paul mentioned, things happen during life as well as when death comes. So it's important really to start with the documents that are essential while you are still alive. Should something happen to you, should you become incapacitated, should you not be able to take care of everything for yourself. So first and foremost, the power of attorney. The power of attorney appoints an agent to handle financial matters if you become incapacitated. It gives them authority to deal with Social Security, to deal with your retirement accounts, life insurance policies, safety deposit boxes. These days, most powers of attorney also give access to the agents to handle your digital records and your social media accounts. If you haven't updated your power of attorney in the last 25 years, you may want to do so, because having access to those records and those accounts is as important as maybe being able to get into that safety deposit box that you opened 25 years ago but don't remember where you put the key to it. And then also it allows the agent to make certain lifetime and charitable gifts to continue those gifts that you've been making during your lifetime if you're no longer able to have the capacity to do those on your own. So really, during your lifetime, the power of attorney is really important. And it's important to make sure that you have that in place and that the person who is given that responsibility is somebody you trust and that they understand the roles that are related to that. The second document, also very, very important during our lifetime, is your healthcare surrogate and living will. And those are the documents that provide for someone to serve as your healthcare agent should you become incapacitated and can't make medical decisions. Paul mentioned the client who unfortunately got sick and had a diagnosis, but there are other situations, emergencies happen, car accidents happen, and other last minute situations happen, and where you're not able to make medical decisions for yourself, it's important to have somebody appointed who can make those decisions for you.
realistically, life's going to happen, guys. You know, you're far more likely to be injured and put in a hospital for a period of time than pass away prematurely. You know, it could be biking accident, if you ride a motorcycle, being hit by a drunk driver, just whatever life throws at you. I know it's kind of grim now, guys. It'll get a lot better, I promise. It's not all dark here, but just again, when life happens, you just want to make sure that you're prepared for it, you know. Make sure your mortgage is being paid, that sort of things while you're in the hospital.
And a few things with regard to that. I frequently see where clients will sometimes name both of their kids as their medical agent. Make sure you're clear in those documents if there is more than one person making those decisions, if each can act independently or if they need to act unanimously. It definitely can get complicated. And most importantly, they are making medical decisions on your behalf, for you. So make sure that whoever you've named and appointed, that they understand your desires and what you would want done, not what they would want done for themselves. And that's especially important with regard to the living will and end of life decisions. And I know Paul said we're not going to be so morbid, but really it is important in these situations for you to make sure that it's your desires that are carried out.
Yeah, and with these documents too, you can write in your wishes, and there's a lot of different things that you can do to help control. So, for example, just on the power of attorney, that can either be something that's in force that the person can act on your behalf starting the day you sign the doc, or that can be what's called springing, where upon incapacitation, where that's needed, then it becomes active and they can use it at that time. So there's a lot of language that can be put in there to help protect yourself and protect your loved ones. So it doesn't have to be a blanket document that just gives them free reign to do everything on your behalf.
Absolutely. Although Florida doesn't allow for springing powers of attorney. So every state does have its own laws, but it is important to make sure you know what you are signing and what powers you are giving to whom and when.
Yeah.
So go on.
The first two docs we talked about, the power of will, medical directives, those are docs that you need while you're living. You know, those are in case of incapacitation, if something happens, make sure your needs are being met. These documents are to help once you pass away to transfer assets to your heirs.
Absolutely. So the revocable trust is, and we will talk about it further a little bit later on, but the revocable trust is one means of holding your assets during your lifetime, titling your account into a revocable trust. And then the revocable trust will provide for the distribution of those assets when you pass away. The advantage of having a revocable trust and putting assets into a revocable trust is that you will avoid probate. And we're going to have lots of conversation about that process as we proceed. The last will and testament, aka the last will. So that's, again, 31% of you say you have a last will. It will identify who you want to serve as your executor or personal representative to handle your estate. It's the document where you appoint a guardian for minor children. And it's the document that sort of lays out where you want your assets to go, where you want your stuff to go, including all those dishes and knickknacks and all the personal property. Frequently, the last will also include burial directions, not always. And then the other documents that we have listed here are the beneficiary designations, and Paul can definitely talk about that. But it's important that while you think you have everything in place, to confirm that your beneficiary designations, both on retirement accounts and on life insurance policies, are up to date, and that you have both primary beneficiaries listed as well as secondary beneficiaries listed should something happen to the primary beneficiary.
Correct. Yeah. Just a side note here, life happens. And these are things that should be reviewed from time to time. A lot of times when I'm doing a financial plan, people say, "Oh yeah, I got my beneficiary on my 401k or my life insurance policy is already set." I like to review those anyways because I can't tell you how many times I've seen a former fleeing, an ex-spouse, a dead parent that was named as the beneficiary, and they haven't updated it since then. So it is really important just to review those things every 3 to 5 years, just to make sure they're as current as possible.
Another important point. It's great to have all of these documents in place. It's important that someone knows where they are when they need them. This is not the type of thing that is useful if it's thrown in the bottom of a drawer or in the attic someplace where no one has access to it and no one knows where to find it. When the documents are needed, this is one thing, please try and keep it organized. As well, keep lists of your financial accounts, your brokerage accounts, someplace where someone can find it, because they can only handle the assets that they know exist. I have had clients with situations where years later, someone's going through a desk drawer and finds a life insurance policy for their father who passed away 3 years before, but no one knew that that policy had existed. Similarly, if you do have funeral instructions, if you've already made, if you've already planned and have prepaid for burial situations, make sure someone knows and where those documents are and what your goals are. It doesn't help if they don't find that out until many, many weeks later when things have already been done. And finally, along those lines, in today's day and age, keep a list of your online passwords somewhere. I'm not saying you should share it with everybody or anybody, but make sure that it is updated and that there is a way for someone to find it. My father, who's 83 years old, keeps everything on a little 3x5 card in his desk drawer. And as he changes them, he'll scribble out a password and add another one. At least I know where to find that card when the time comes, God forbid. But yeah, it's important that somebody knows where the information is. It doesn't help if you've done all the planning and no one can find it. So,
unfortunately, yeah, go ahead.
No, I was going to say, this is the way it used to work, right? It was just a whole bunch of junk and one day, son, it will all be yours. But it's not that easy these days. It's much more complicated.
Yeah, we all have that family member that's a collector.
Yes, before we get too far away from that last topic, just because I think it is important and I have a lot of people asking about it, do you actually need a last will if you have a revocable trust?
Oh, that's a great question.
So the answer is yes, you still do. And frequently it's called a pour over will, because what the last will is going to say, any of the assets, any assets in my name when I pass away will pour over into my revocable trust and be distributed pursuant to the terms of my revocable trust. But there are lots of things that come up, and the last will handle all of those assets that are not in your revocable trust, including the tangible personal property, and as we'll see, other items that come up. So it is important to have a last will, even if you have a rev trust. Yes.
Thanks. I'll try to hold questions till the end. There's a lot.
Yeah, we'll get more into their functions and how they kind of work together.
Okay.
So when we look at assets and how they transfer to loved ones, it can happen one of 3 different ways. All right. The most common one is actually number 2 from what I've seen. Carrie, you can let me know if you've seen different. But a lot of assets have names on them, whether it's, beneficiaries named on them, like retirement accounts, like your 401ks, the life insurance policies, IRAs. A lot of those just have a named beneficiary. So it just follows the contract and goes to the named beneficiary. Assets held in a trust, most commonly a revocable trust, also work the same way. A little bit similar but different is number 1 by title or operation law. Here, this is either a joint account where both the husband and wife's name is on it. So when one spouse passes, it just goes to the second spouse. Or this could be an individual account where you're adding a beneficiary. That's called a TOD, or tenant, POD, payable on death. is where that kind of comes into play. And then
Right.
the last one, which is the one that we want to try and avoid, is by probate. Probate is the state process where the court determines where the money goes and to whom, and it costs a lot of money and a lot of time to go through that process. So we want to try and avoid this as much as we can by either using a trust or putting on a beneficiary on the account.
And just one note on the titling of assets, assets that are held jointly with rights of survivorship or tenants by the entirety. Bank accounts are sometimes titled payable on death to someone. For brokerage accounts, they're frequently titled transfer on death to another person. It's the same thing. So if you have a brokerage account and it's titled transfer on death, that's the same as a bank account being titled payable on death. And probate administration, as Paul mentioned, is not necessarily the way we want to handle most assets. Inevitably, there will be some situations where there will be some assets that will pass via probate. But if you have a life insurance policy or you have a retirement account, and you don't have a named beneficiary, it will have to go through the probate process. So again, make sure those beneficiary designations are up to date. Tangible personal property, for the most part, will go through the probate administration, will be handled by your last will. So it says move to the probate process, and Paul, maybe we'll move the slide to maybe even let's go to the next slide. I think we can sort of pass through this one and talk about the probate process.
Yeah,
So
no problem. I do want to touch on something here real quick. So again, the goal is to use everything on the right. We want to avoid probate. Just to give you a real life example here in California right now, we all know that the definition of a millionaire in California is a homeowner, right? Well, if you have $1 million estate, which includes the value of your home, when you pass, if it goes to probate right now, the cost is going to be around $25,000 for that. And that does not include attorney fees. That's just court fees. So all in, just for your heirs to get access to the money and be told that they're the beneficiaries, which they already know, it's going to cost probably somewhere in the neighborhood of about 35 to 40 grand total for $1 million estate. And it's typically going to take about 8 to 10 months to get that process done right now, at least in Orange County.
Yeah, probate is not necessarily a fun process, and it is expensive. So probate is where it's a court supervised process whereby the last will, if you have one, is deposited with the court and it says so-and-so passed away, and here's a copy of the death certificate, and here's a copy of his last will, and the last will names somebody who's to serve as executor, and you file all the documents appointing that person. The court reviews it and says, okay, executor is now appointed, and now the probate process begins. And then there are a series of things that need to happen before assets get distributed. The court needs to make sure that the will is valid. They want to make sure that there are no creditors that have claims to assets in the estate. And so not only is it a lengthy process with lots of paperwork that needs to be filed and attorneys need to be involved, but the assets that pass through probate are frequently, for the most part, frozen. So your beneficiaries don't necessarily have access to them, to those funds, while the probate process is happening. Similarly, your last will becomes a public record. Now, for most people, that may or may not be an issue, but I don't know, if TMZ is following you, you might not necessarily want them seeing your last will and figuring out who you're leaving your assets to. That's also where the Rev Trust comes in, because while the last will is a public record, your revocable trust, which may really set forth what happens with your assets, is not a public record, and that does not necessarily need to be filed with the court and accessible. if you don't have a last will, I mean, we're talking about all this, but if you don't have a last will, you still go through the probate process, and that's called intestate. The state will figure out where your assets go, and every state has different rules for how assets get distributed if you don't have a last will. In Florida, if you don't have a last will and you're married and you don't have kids, everything goes to your spouse. So maybe that's easy. If you are married and you have kids from your spouse, again, everything goes to the surviving spouse. So maybe that's what you want. If you have kids from a prior marriage, half goes to the spouse, half goes to the kids. In California, it's more complicated if you have a spouse and kids. I think half of the community property goes to the spouse, and then a half to a third goes to the kids, and then the separate property goes to the kids. I'm not quite sure about that, but every state has their own rules for what happens if you don't have a last will. But we really don't want that to be the way that our assets get distributed. So even though we want to avoid the probate process by making sure that our assets are titled otherwise and they're distributed otherwise, the last will is still important to handle those assets that will fall under, the probate process or be part of your estate.
Perfect.
Okay, so little summary of the reasons to avoid probate. It requires court involvement, legal fees, filing fees, attorneys, expenses. It takes time. There's a creditor period where creditors have a right to come forward and make a claim against the estate. The court review process can take months and months, and frequently when you file something, the court will come back and say, no, we want something else. We've changed our policies and procedures, and now we need you to sign in 3 places, not 2 places. Another issue is it does freeze assets. And I recently had an interesting situation with an advisor with a client who had a very large estate, well over $10 million. He didn't have real family members and named as his executor. Had a will, but nothing else. Named as his executor his old friend from college, which was great. They were happy to serve in that role. The problem was it froze the assets in his estate, and mortgage payments on his $8 million co-op needed to be made. And the executor didn't have the resources to make those payments. So they were actually looking to set up a line of credit against the estate so that they could have access to funds to pay the mortgage payments on the co-op so that the property wasn't foreclosed on during the probate process. So again, to the extent we can avoid probate and keep the assets transferring outside of that process, it's really a benefit to your loved ones.
Yeah, and the whole thing with probate here, just as a reminder, guys, is this is all state specific. So in California, like the example I gave you, we want to try and avoid that like the plague, if at all possible. If you live in a state like Texas, their laws are very forgiving. The process is very quick. And actually, most estate planning attorneys that I've worked with in Texas really don't use trusts. So every state is different. Just keep in mind here as we're talking today, we're giving a lot of generalities into what we're seeing most commonly, but there's an exception to every rule.
I love
Again,
that
that's why
random comment because somebody just told us that in the chat box, just sharing their own experience that they had a friend that did that. So it's just fun that you happen to say that.
Oh, okay. Good timing.
Somebody else also told us that they just finished probate last year and it took 19 months to complete. So just example, for all those 13% that said leave it to the state, they can figure it out. It's we have some other people in here saying, man, that's a difficult process.
Yeah. Yeah. I mean, I've had a client that was worth over $50 million one time, said I came into this world with nothing and his goal was to go out of this world. And he's just like, I made my money, my kids can do the same. He literally didn't care. There was no estate plan for him. He's just like, I'm good. Don't care. Okay.
Well,
If that's
depending
what
on
you want to
what
do, that's
state
what you want to do.
depending on what state he lives in, the intestate rules
California.
probably left it all to his kids. It's just the process by which they're going to have to go about getting it is going to be complicated, lengthy, and expensive.
Yes.
So, so the ways we avoid the probate process, as we mentioned, accounts that have named beneficiaries can avoid the probate process. Accounts that are titled jointly or payable transfer on death avoid the probate process. And then all those other accounts and assets, we title them into a revocable trust. And that will allow you those assets to bypass the probate process. So a revocable trust basically is the same thing as holding the assets in your own name during your lifetime. They're still yours. The income is still reported on your own 1040, and the revocable trust basically functions like yourself. For the most part, the individual will be named as their own trustee of their own revocable trust. As it says, it's revocable. It can be amended or revoked at any time during your lifetime. And it's just like having your own assets. If you become incapacitated, that's the first place where having your assets titled in a revocable trust is helpful, because the successor trustee can use those assets for your benefit without having to go to the court and be appointed as a conservator or go through a guardianship process in order to have access to those assets to take care of you. So even during your lifetime, having those assets in a revocable trust when you become incapacitated is beneficial. Then when you pass away, your revocable trust, the assets in your revocable trust, will pass pursuant to the terms of the trust without having to go through that probate process. So the revocable trust basically at that point becomes what you thought your last will was, and it will set forth what happens to your assets when you pass away, where you want them to go, and how you want them to go to your loved ones.
Yeah. A few things I want to touch on here. Number one, the trust is so popular because it gives you flexibility beyond the grave. For example, in the trust that I have for my family, I have two minor kids. I know when I was 21 years old, I was highly irresponsible. I wouldn't trust myself with a lump sum of money. I ain't trusting my kids with a lump sum of money at 21. So I have rules in there that the kids can't access the money until either age 30, or if they want to use it sooner, there's limits on how much they can use for college or for a first-time home purchase. So I'm doing that in a way to protect themselves. But a trust is what's going to allow you to have more control beyond the grave, to help really make sure that your wishes are really carried out to the best chance for them to be carried out, at least. When we talk about trust here, 90% plus 95% of all trusts are revocable trusts, meaning that they can be changed at any point during your life. These are far and away the most common trusts. There are some irrevocable trusts out there, and we can talk more about those strategies as needed, but those are going to be for more complex advanced estate planning techniques, typically where we're trying to limit or avoid paying estate taxes, or where we're going to use irrevocable trust. So for today's conversation, and just most conversations in general, the vast majority of trusts are revocable trusts.
I'm just going to tee you up. We're going to be doing that in the Q&A because I already have a number of questions on irrevocable trusts, but I'll let you get through all the prepared remarks first, and we'll address those towards the end.
Okay. Paul, I think we've sort of explained why the advantages of having a revocable trust versus just having a last will.
So, good.
And this, we just put little gold stars so you can see. And even the gold star saying the initial cost of a last will is positive versus a revocable trust. The reality is that's not usually the case at this point. The cost differential of an attorney preparing a last will versus a rev trust is minimal. So I might even get rid of that little gold star on initial cost.
Just think of it this way, right? When we're all driving, we've all been in rush hour in LA or whatever big city you live near. There's typically two lanes. There's the toll road or the normal lane where you're stuck in rush hour traffic. The rush hour traffic that's slow and bogged down and whatever, that's your last will. Pay a little bit of money now so your heirs can get the toll road, the express lane, with the revocable trust. It's going to be far faster and far cheaper because 2,500 bucks, 5,000 bucks for a basic trust now is a lot cheaper than 25,000 that your state's going to have to pay when you pass if you go through probate in California.
Absolutely. But Paul, you touched on something that is part of the discussion, which is you can go forward. The revocable trust or the last will still is going to set forth what you want to happen to your assets when you pass away and where do you want your assets to go. We talked about the intestate default provisions, but do you want all of your assets to go to your children? Do you want certain assets to go to your spouse and then to your children? Are there charities or other institutions that you want to leave money to? Are there other people in your life that you want to take care of? All of that would be in your revocable trust as part of the remainder distributions when you pass away. And like you said, you don't trust your kids to get everything outright at 21. I'm totally with you. I'm a big believer in keeping assets in trust for lifetime, having provisions in place so that those funds are accessible and the trustee can make distributions to your beneficiaries. But there are certain advantages to keeping them in lifetime trust. They're protected from creditors. They're protected from certain taxes. So that's a conversation really to think about both in terms of your philosophy. If you think assets should be just given outright, let your kids figure it out for themselves, or you want to control things from the grave. And again, those are conversations to have with your financial advisor and with your estate planning attorney.
Absolutely.
and then-
Titling of assets is really important here. So just for example, if you want money to go to a charity, maybe there's a 503c that you believe in and you want to donate some money to upon your death. Well, if you do that from certain accounts, like an IRA or 401k, for example, that money can go to them all tax-free. So with proper planning, you can even reduce more taxes and make sure that your estate's being maximized to meet all your wishes.
Absolutely. And that is a conversation to have with your advisor, because different assets can pass more favorably, tax favorably than others, depending on who the beneficiaries are going to be. And then the other thing to think about are other unique circumstances, special situations. If you have beneficiaries with special needs, it's important that assets that are being distributed to them, assets that they're going to inherit, are held perhaps in a supplemental or special needs trust, which will allow them to have access to those funds, but won't compromise any government benefits they could be receiving. The last thing you want is to not plan accordingly and for the inheritance to end up compromising some government benefits they receive or other resources they're entitled to. So it's important, if you do have certain situations, or even if it's not a special needs situation, but if you have beneficiaries who may have drug issues or other situations where you need to be more careful about how assets are distributed to them, it's important to speak to your attorney and to make sure to make those plans and not just to, sort of ignore them or dismiss them or, not want to be public with them. Obviously, your conversations with your attorney are confidential, but those aren't things that you should just ignore because you don't want to think about. Okay, so now we get to the next piece of the puzzle, which is Uncle Sam and taxes. So we figured out where we want our assets to go and how we want them to go. And then there's always Uncle Sam who's sitting there saying, but wait, I want my piece of the estate. So let's talk about primary basics of federal, and this is only federal, I'm not getting into state, but federal estate taxes. Everybody is entitled to a lifetime gift and estate tax exemption. In 2024, that amount is $13,610,000 per person, which means a married couple can pass $27 million plus without any estate tax. So for most people, federal estate taxes really aren't an issue today. If you, as a married couple, have more than $27 million, then yes, there are some estate tax issues that need to be considered. You should definitely be speaking to Paul and your financial advisors about those issues. But for most people today, the federal estate tax is at $27 million per couple and $13.6 million per person really is not a fundamental issue. But that may change in a few years because under the current federal tax laws, effective January 1st, 2026, that lifetime exemption is scheduled to be cut approximately in half. It's based on where the exemption was when the legislation was enacted and inflation adjustments for inflation. But under current federal estate tax laws, the lifetime exemption will reduce down to something around $6.5 million per person beginning in 2026. And so that'd
be 13 million for a couple approximately.
Approximately $13 million per couple. Now, again, for most Americans, it's not an issue. But if you're living in a 3-bedroom house in LA, it may be an issue just there alone, given the price of the cost of real estate these days in LA. So it is something that more people are going to need to think about. And no one really knows what's going to happen with the estate tax exemption. I'm not a gambling person, so I'm not going to put bets on it. But in order for that exemption to not be reduced, Congress actually has to do something. They have to pass new legislation or it will automatically sunset. So there's definitely, if anybody can tell me what Congress is going to do in the next 2 years, with any certainty, please let me know. But I don't think anybody can really predict exactly what's going to happen.
Yeah.
So above that exemption, whether it's at the $13.6 million per person or $6.5 million per person, everything above that exemption is federally taxed at 40%. So let's just say you have an estate of $20 million and 13.6 of it is exempt. The other 6.4 million would be taxed at a federal rate of 40%. Now there is a deferral, an exemption for anything above that $13.6 million you leave to your spouse. So if you're a married couple, on the first death in most situations, there won't be a federal estate tax due because anything above that lifetime exemption will, if you love your spouse, be left to your spouse and it won't be an issue until the second death. So those are the basic estate tax rules. In addition, there are annual gifts that can be made. And currently, the annual gift exemption is $18,000 per person. And that's per donee, which means anybody can give $18,000 a year to as many people as they want, and those gifts are not taxable. So you can be made, and a married couple, therefore, can be giving $36,000 away to as many people as they want every year. And that's another way, if you are in a taxable estate situation, to sort of reduce that overall lifetime estate by making gifts during your lifetime on an annual basis. And again, they can go to as many people as you want. So you can leave $18,000 to each of your kids and your grandkids, your nephews, your nieces, your housekeeper, if you like whomever you want to make those gifts to, $18,000 per year per person. And that amount, that 18,000, is adjusted for inflation. It wasn't that long ago that annual exemption amount was at 14,500, then 15,000. Given the economy in the last few years, it's gone from 16 to 17 to 18, quite precipitously. But so that's the other basic tax exemption to consider. The other thing to think about when you're doing tax planning for your estate is that when you pass away, assets that are in your estate receive step up in basis when you pass away. So if you own Apple stock and you bought it when it was $2 a share, if it's part of your estate when you pass away, your beneficiaries will get step up in basis to the current fair market value, which will save them on capital gains taxes when they do sell that stock, if they do ever choose to sell it.
Yeah, there's a lot of planning that could be done before death to maximize your estate and to minimize the taxes that are getting paid. So again, this is where
Absolutely.
working with a financial planner and estate planning attorney in conjunction is ideal. And then with irrevocable trusts, as we mentioned before, these are really when you're dealing with that 40% tax rate on estate plan, right? Because if you have $1 million over that exemption, so let's say that exemption is 13 million starting 2026, your estate at that time is 14 million, you would have $1 million subject to estate taxes at a 40% estate tax rate. That means 400,000 is going to the federal government, 600,000 is going to your heirs. So if that is a concern, there is GRATs and SLATs and QPERTs and Dynasty Trusts and Grantor Trusts and IDGITs and widgets and everything in between that can be used. And yes, all of those are real trusts except for widgets. That was just made up. But there are so many different trusts that can be used that are irrevocable that will either freeze the value of your estate. So let's say you have a bunch of stock and it's worth 5 million now, but you think it's going to be worth 10 million, or maybe you have a business that you own and it's the same thing. Or there's techniques that you can do to keep the valuation for estate planning purposes at 5 million and get that future growth out of the estate. So that's just one of the many types of vehicles that can be used. If you are concerned about being above that 6.5 million limit per person starting 2026, don't wait until this time next year to do the planning. Attorneys are already getting booked out now. So this is something you really should be thinking about today, but you don't have to necessarily implement until end of next year, assuming nothing changes going into 2026. Like Kara said, we don't know what's going to happen with Congress, so anything can change between now and the next 18 months.
Something will change. That I'm sure of. Things will change between now and 2026. I just don't know where they're going to go. But using irrevocable trusts are important in certain situations. It's important to recognize that gifting assets to an irrevocable trust, as Paul mentioned, can freeze the value of the gift to that trust, and therefore limit how much is subject to tax. But it's important to recognize with a lot of these strategies, you do have limited or no access to the assets. You do lose control over the assets. And there are various ways of structuring them, in terms of the beneficiaries, whether they're family members or charities. If that's something that you do want to discuss, again, talk to your financial planner and really, you can address all the different strategies for how best to limit your estate tax using different trust vehicles.
Yeah, and one thing I'd just like to say is these might seem like big amounts, and some of you may be thinking this doesn't apply to you at all. Well, if you guys are on these webinars, you're obviously interested in trying to improve your financial literacy and make the right decisions. If you're taking what we discussed to heart and listening to these and applying these in your own lives, I do hope that a lot of you guys do get there, that there are some 100+ millionaires down the road that we're having some of these discussions with. So hats off to all of you guys that are out here watching this, and we thank you very much for you guys taking the time to do that.
And even for those of you who aren't 100 millionaires yet, there are certain situations where it may make sense to consider gifting assets to an irrevocable trust, even while they're worth very little. If there's a potential for a major event, and those assets may go from being worth nothing to lots, gifting them and getting them out of your estate while their value is low is a great estate planning tool. So you don't need to have $100 million to have an irrevocable trust. In fact, if you have $100 million and you don't have an irrevocable trust already, it may be too late. But it is something really to consider if you have assets that you think may appreciate considerably in the years to come, to start thinking about doing some planning with those assets.
Yeah.
And again, that's a topic for Paul.
Yeah, one of the most common ways of doing that is what's called a rolling GRAT strategy. That's a grant to retained annuity trust. This was actually popularized by the Walmart family. So the Waltons, right, they have stock in Walmart, and that stock keeps going up and it keeps doing well. And so what they wanted to do was freeze the value of that stock because it was a huge chunk of their net worth for future generations. So what they're doing is this was called the rolling GRAT strategy. And if you want to talk offline, happy to do more. But essentially, they're freezing the value of the stock at today's value and getting all future growth out. So that's just one of many, many examples that we see out there.
Yeah, there are many. There are many different types of trust and vehicles. But again, that's a conversation. That's not a topic for today's conversation. That's a conversation for you to have with Paul and your financial advisor.
Chad, can you do our last poll?
Thanks, group. So yeah, as we wrap this up, we just have one more slide on kind of common mistakes. But before we get to that, I did just launch another poll just to kind of check. This is single choice, only pick one, because I think you can only have one of these. But just let us know, like, have you already spoken with your family about estate planning, right? I think it's one of those things a lot of people push off, and it's uncomfortable to have these types of conversations. And I do promise you, results from this is anonymous. If you have family members on here and you want to say the dog or cat is getting it all, your family members that are also attending have no idea that you would have said that. Let me leave this up for just a couple more moments as we do have responses coming in. And I will close it out. Let me share results. I think we have some pretty good results for this thing, actually. I think we already have 35% have said yes, which is great to see. Another 35% said to a limited extent, but it's kind of like need to know, which I think is actually really common too. So 70% of the people on here have already actually spoken with some form of family about their plans. 9% say no, 19% say no, but after watching this, I'm considering it. A couple of people did say yes, the dog or the cat are getting it. I love that response because I love my dog. And then we have a couple of people in here saying they're getting nothing. I'm bouncing my last check. That's actually what I told my parents to do. And that's what I think Paul's plan is too.
Yep.
Let me stop sharing and let you guys wrap this thing up.
Yeah.
So, Chad, along those lines, I was just reviewing a pet trust that someone had put in place in their estate plan and figuring out how much to fund the trust that's going to take care of their dogs when they pass away. The bigger issue is who wants to take care of the dogs when they pass away. It's one thing to leave the assets, but you need to find that caretaker who's going to give them as much TLC as you will. So common mistakes. Number one, the do nothing plan, which thankfully, according to our first poll, most of the people on today's webinar have at least done something.
Yeah.
And number two?
Unless you have a really, really basic thing where maybe you have some internet prowess and whatnot to do it yourself, Most of the time, people tend to try and do this cheap. And it's not that expensive to get done correct. And this is not something you want to make a mistake, because if it's not correct, if it's not done correctly, it doesn't apply, and then it's going to go through probate. So trying to do it yourself can be dangerous unless you really have sufficient knowledge and the tools and resources to do it on your own. We see a lot of times, we've talked about this, just overlooking beneficiary designations. As I've mentioned before, every 3 to 5 years, update these. You probably don't want the money going to an ex-spouse. They're probably ex for a reason. You may not want the money going to that high school or the college playing, to the whatever. Or you may have a parent name there that is no longer alive. Whatever the case is, just make sure that you're looking at these and updating them every 3 to 5 years. Same thing on the revocable trust. If you have a revocable trust and no pull over will, and you forget to retitle or rechange the names of the assets into the trust, that's just an expensive piece of paper. So again, if you set up a revocable trust, that's the first step. The next step is your investment accounts that are going in the trust, the house that's going in the trust, whatever assets are going inside the trust. Now their titling needs to be changed. So you need new account paperwork with Schwab, or updating the deed on the house, whatever the case is, to get those put into the name of the trust. And then with the trust and estate plan, we want to update those again about every 3 to 5 years. At minimum, you just want to review them with a professional to make sure everything's current. A common example of this is when I first started in the industry, there was this trust structure called an AB trust. It worked at the time because of state planning rules. Well, what happened is that where we talked about the exemption today is 13.5 million going to 6.5 million starting in 2026. That used to only be available at the time of someone's death. If you didn't use it then you lost it. Well, that's why people use the old AB trust structure, was to account for that. Nowadays, there's what's called portability. When the first spouse passes, you can move all the assets to the surviving spouse, not use any of that exemption amount until the second spouse passes, and then you use everything at one time. Well, if you have an old AB trust, you're actually missing out on some of that, and it creates additional tax headaches, and it's a lot more complicated than a basic trust that you need today. So that's just one example of why you want to update your trust over time, and you want to make sure that the plans stay up to date. And the last one here, and we just covered this, but it's so important to communicate your intentions and your wishes to your family. So whoever's your medical directive, write in there what you want to have happen, talk to them about it. When I'm doing estate planning for my clients, the number one thing that I see is people don't care about leaving money. If they can, that's great, and they want to. But the biggest thing that people want to pass on is their beliefs and their values. And so that is what is so important with estate planning, is that's going to be your last chance to be able to convey those wishes and whatever that legacy is that you want to leave. That's going to give you the best chance to do that.
I would add one, you're absolutely right, Paul. And I do think that the legacy and your priorities that you want to communicate to your family are essential, and that's important for you to do. The one last piece, the last common mistake I will mention is, again, not making sure that your family or your attorney or your financial planner or your executor knows where the information can be found. Again, keeping lists, making sure those records are available so that when the time comes, the people who need to handle your final affairs know what those are and where to find them. If you do all the estate planning, but no one can find it, it's problematic. So make sure to do the estate plan, and then make sure that somebody knows where it is and how to access all of your records and get to that information.
Thank you too for a great presentation. We have a ton of questions. I would definitely pull up the Q&A box and the chat box. I think a few people forgot about the Q&A box. I have questions in both, so I will let you know where they're coming from. But again, for anybody that does have follow-up questions or maybe is looking for an estate planning attorney, I think always the best place to start is your friends and family, right? Your trusted people in your life that might already be working with somebody that they think did a great job. And if you don't have any of those, right, obviously we have our information for Paul at the top of the screen to reach out. Again, Kara was here just to help and support us today. She does not practice estate planning law anymore, at least not right now. You never know down the road.
One other resource I've got a list here, Chad,
Yep.
is we do offer, if you are the surviving spouse or if you are the executor or trustee and you're dealing with a loved one that passes, or if you want to make it easier for your heirs after you pass, we do have what's called the survivor checklist, which is a list of the things that whoever is the survivor and taking care of a loved one that's passed, all the things that they need to do with important numbers to things like Social Security. That is something that we can provide complimentary as well. So feel free to reach out if you just want to get that checklist as well.
Awesome. Okay, so Zoom's been doing some weird things, right? Last week it turned off the ability for people to even chat with us. I fixed that setting, and now they took off the thumbs up ability in the Q&A box. So we have a lot of questions that people haven't been able to upvote, so I can pull them to the top. So some of them I will try to merge together because we do have a few that are similar. I think the one that we have the most questions though are, and you kind of touched on the irrevocable versus revocable trust, right, late in the presentation. Could you kind of explain the biggest differences and really the pros and cons? Like I think call it the top couple reasons somebody might want to consider irrevocable instead of revocable.
Okay.
So they're not one or the either. You would have a revocable trust either way. An irrevocable trust is going to be an additional, or several irrevocable trusts maybe, in addition to your revocable trust, as means of gifting assets out of your estate during your lifetime to take advantage of that current $13.6 million lifetime exemption, and to take up to that, to take certain assets and move them out of your estate currently at their present value. And again, they wouldn't be instead of the revocable trust. The revocable trust would still be there for any assets that are still in your name when you pass away.
Yeah. So outside of like it's not uncommon for someone to have more than one trust, have a revocable and maybe some irrevocables or something like that. If you own a small plane, you may have what's called a DAPT, a domestic asset protection trust, that's set up so if anything happens, it reduces the liability for your plane. If you have a family home, so like there's a client that we work with that there's a cabin in the mountains that's been in the that's been in the family for generations. That's in its own trust, so that it can last several generations, and it keeps the value out of people's estates, and it has its own rules on who can use it and when and all that sort of things. So it's not just sometimes around the estate exemption. There may be other reasons why people are using an irrevocable trust.
Absolutely.
Okay, so the next one, this is coming straight from the very top of the Q&A box that came in pretty early. Person acting with power of attorney may have a lot of responsibilities. Can the power of attorney document have a provision to pay the person for handling those provisions?
So every state is different, and I'm not going to give any legal advice. I don't believe the real answer is I don't know, and every state is going to have different rules around it. I don't think under the durable power of attorney itself, you can have provisions for making payments to them for serving in that role. But every state is going to be different.
I haven't seen it at the power of attorney level. Now remember, power of attorney and trusts are separate, right? I have seen it where trusts, which are very complex, there can be some small fees there can be fees paid to the trustee who's overseeing the trust, and I have seen that. I've never seen on power of attorney, not saying it can't happen, but I'm not an attorney and not something that I've seen in my time doing this.
And Paul, you're absolutely right. Trustees' fees for serving as trustee of the trust are very, very common.
Yeah.
Okay, the next one I have here, and this gets for a community property estate specifically, can you prepare a separate will and trust from your spouse for prior assets and inherited assets?
So yes, you can do separate planning. Typically, it gets tricky on this. If the assets are stolen separate and kept stolen separate, the best thing to do in a community property estate is have this dealt with before marriage or during marriage if it comes up, making sure that asset stays sold and separate and none of the money's used to commingle with the family. Real life example, I had a client, for example, that inherited money, lived in Arizona, which is a community property state, used some of the inheritance to purchase a home for the family and then subsequently got divorced. The ex-wife got the home and all the money that was from that inheritance because that was used, it was no longer sold separate, it was now used for the family purpose. So planning like that can be done, but if it's not done correctly, they can quote unquote pierce the veil and get access to the money. So got to have a really good attorney in those situations.
So next one, this goes to just getting power of attorney in the first place. Can I just go to a mailbox notary and get power of attorney, or is it something special that you need?
I'm not sure what mailbox notary is, but most states will have a sort of form power of attorney that you can print and execute. It does in most states, and again, every state has different rules. It will probably in most states need to be notarized and witnessed. And usually the form includes specific powers that you can check all or none, initial which ones you want your agent to have and which powers you do not want your agent to have. As we discussed from the beginning, the power of attorney is really a very powerful document. It's not the type of thing you just want to execute without giving real consideration to it and who you're naming as that agent. So I do think you need to be thoughtful, both in terms of what powers you're giving to that agent and who is serving in that capacity.
Absolutely.
Okay, next one is, what if you designated somebody as a beneficiary who passes before you? Where does things like life insurance, et cetera, go? I think that might just go to make sure you keep these things updated when loved ones pass.
Exactly.
That's the number one answer, yeah.
That goes to Paul's, make sure to review your estate planning, your beneficiary designations on a regular basis. And again, that also goes to making sure you review your primary and your secondary beneficiary designations. If your beneficiaries are no longer alive, then the default in most states will be that it will pass to your estate and then go through the probate process.
Yeah. I can answer the next question kind of along with this one, Chad.
Yep,
so the next
I love
question is, what happens if your spouse is your primary beneficiary and your minor children are your secondary beneficiary? Number one, this is a good setup. If you want to make sure that assets are getting passed on appropriately, where you have a first and a contingent. It gets a little tricky, and you want the spouse typically named primary, so it goes to them outright. There's no complications. A lot of times it can make sense to name the trust as the contingent, especially if the kids are minors. If the kids are minors and something happens to both parents and the life insurance policy goes to them, there's going to be a guardian that's going to be in charge of managing the money until the children reach 18 or the age of majority in your state. It's 18 for California. That's why I say that. But once you reach age of majority, the child gets access to that money, can do with it whatever they want. As I talked about, unless you want to have that happen, having it go to a trust as a contingent typically is going to be a safer route for most individuals.
Next one I have is, what if a trust document references a retirement account, but the beneficiary on the retirement account has not been named as the trust or in the trust?
So, go ahead, Kara.
And I was going to say, the retirement account is going to pass pursuant to the terms of the contract with the plan administrator. They're going to look at that beneficiary designation form, and that's what they're going to use for who the beneficiary of the account is. If there's a discrepancy between what is in a trust and what is on that beneficiary designation form, you may end up with a legal battle between beneficiaries fighting it out, but the default is going to be in most states that it's going to pass pursuant to that contract with the plan administrator.
Yeah.
I mean, a special note on that. I mean, especially in 401k, 403bs, and IRAs, like you can name the trust as a beneficiary. And so that's just something to talk about, especially if you have a spouse, making sure that they're open to that, because you probably need spousal consent forms to be signed to. But that would be the route around that, isn't take a beneficiary off and make the trust the beneficiary and spell out all of your wishes in the trust. The next one I have here, and this might get to really old estate planning, but I recently found an insurance policy for a deceased relative who passed around 20 years ago. Like, any chances on still collecting on it?
It's a very good question. I had a situation, it wasn't 20 years. I would contact the insurance company and find out how you can proceed. But again, it speaks to the need to keep your records someplace where someone can find them, because, you know, it would be a shame if that policy doesn't get paid out simply because no one ever found out about it. But I would address it with the insurance company.
Next one I have here is, I mean, if I don't have a revocable trust, it would go to probate, and it sounds like that's correct. Does it resolve this issue if I put my assets under my adult kids with a clause that I still control the assets, so I can like sell, rent, etc.?
So you wouldn't want to put it under the adult kids' names because it becomes subject to their creditors. They can use the money however they want. They don't have to leave it there for you. Instead, just going back to this chart here, add a payable on death or transfer on death. So just add the kids as beneficiaries. So it's your account while you're living. They have no access to it. If something happens and you pass, they just show a death certificate. They automatically get access to it, and it's not then it's not subject to probate. Otherwise, just have a trust, put it in the name of the trust, and that also will fix that.
Love it. The next one is, if I have a named beneficiary on my bank or investment accounts, but I have a different beneficiary on my revocable living trust, who gets the money if I pass before I update the trust?
So again, it goes to that order of operation. The accounts that are titled in a certain way will pass according to that title. The accounts that are in the revocable trust will pass according to the terms of the revocable trust.
So I'm going to lump a couple together here, but the first one is the top one on the Q&A. If you don't have property, right, like a house and stuff like that, is a beneficiary designation like sufficient, or do you still want a trust, especially if the beneficiaries are children that may be minors? There's a second part of that later in the Q&A that kind of speaks to that normal bank accounts, like savings and checking accounts, that we've heard banks cannot actually be, like bank accounts can't be transferred to minors. They'd have to set up some special type of account. Is there any truth to that?
That is correct in California.
Again, every state's going to have different rules, but UTMA accounts or some other.
It's a custodial account that gets set up.
Custodial account, correct.
Yeah. So what was the first question? Sorry. Or was that it?
The first one, yep.
Okay.
Well, I'm trying to find it. I dismissed it because I thought you had it. Let me ask the next one. I'll come back to that. So I'm going to pull one from the chat that came relatively early. What happens if you live in one state, but your beneficiaries and heirs live in another state? Like, any considerations from an estate planning perspective to think about?
So, sorry, I'll answer real quick just for a California thing that we're dealing with. So we have if you live in Nevada and you set up the trust, typically the trusts are set up in the state you live in and they're governed by that state's laws. That's typically the case. So if you live in Nevada, you set up a trust in Nevada, it's Nevada laws. There are some states, specifically New York and California, that if the beneficiaries live in that state, they may still try and get their clause on it. So the California Franchise Tax Board will still try and get their clause on some of that money if it's going to the heirs potentially. So it's a very complex issue. And that's something, if you happen to have beneficiaries in New York or California, talk to an estate planning attorney about your situation and see how that applies or affects you. Otherwise, it doesn't really matter.
Well, I will also add that some states do have inheritance taxes. In addition, we talk about estate taxes, other states will have an inheritance tax, and they may try and tax a portion of what you inherit as a beneficiary. So there are, again, every state has different rules. It is important to consult with an expert, which goes back to common mistake number 2. Do it yourself is generally not the way to go about handling this.
Yeah, and the states with the inheritance tax are Iowa, Kentucky, Nebraska, New Jersey, and Pennsylvania.
So the next one I have here is, and this is going back to the question we asked, is if you don't have property, I mean, is it fine just to set beneficiary designations on like all of your accounts, like retirement accounts and insurance accounts, stuff like that?
Yeah, if you have named beneficiaries and let's say you're a college student just coming out of college, you have 2 bank accounts and maybe 1 or 2 investment accounts, and that's all you got. Just put beneficiaries on it, have a power of attorney and medical directive, and you should be okay for a while.
I would also recommend having a last will as part of it. Any assets that have to pass through the last will have to be probated, but at least they won't be subject to the intestate laws of the state. So you should have a last will under any circumstance, and hopefully nothing will have to pass through that process, but it is important. And inevitably, assets show up that you didn't know existed, whether it's the refund check from the electric company or whatever else that will need to be cashed. So it's important to still have that last will and to, even if everything's going to pass outside of it.
Awesome. So I'm going to pull one from the chat box. I'm kind of going in order when they're coming in here. A question about QPRTs, like any cons to one?
A QPRT is a qualified personal residence trust. It's a type of irrevocable trust where you transfer the residence to a trust and you can continue to live in that property for a period of time. The value of the gift to the trust is reduced based on your remaining interest of living in the trust. Again, for certain situations, it's a great estate planning technique to use. After the term of that trust, either you have to move out or start paying rent for living in the house. So it is something to think about, but in certain situations, it's a great technique for estate planning. But again, it really depends on a particular situation.
Depending on the state you live in, like Florida, where there's an unlimited homestead provision for asset protection, you do lose the homestead provision. It can make the house more difficult to sell as well. And your heirs are going to inherit your tax basis on that. And you could lose some property tax benefits in the state of California. So there are things to consider with it.
Yeah, it's not a slam dunk. It's definitely something to consider. And again, speak to your financial advisor and your estate planning attorney before doing.
Next one, back to Q&A box is any ways to protect your property and assets against nursing home expenses of your spouse?
There are.
Elder law is a totally different, it's its own special planning. And there are techniques that can be used to protect assets so that you don't become bankrupt supporting your spouse in a nursing home. But again, speak to an elder care specialist to really talk about how that can work.
In California, this happens a lot when they're on Medicaid, which is Medi-Cal in California. And you want to have the state pay for the cost so that there's money left for the other spouse to be able to cover their lifestyle and their expenses. But that is specifically with an estate planning attorney.
So next one, and this is asking about California, although I don't know if it would change in different states, but any idea just the general cost of a revocable trust? Maybe do like the range. I know every estate planning attorney can be more or less expensive, but Any idea the range of a revocable trust and the costs associated?
I would
Again,
say most people maybe 2,500 to 5,000,
I,
maybe.
I think it really depends on where you are. Um, in, I mean, in LA, I would think it would cost a lot more, perhaps. I've seen across the board different ranges. I wouldn't put a number on it, but again, I think most important is to work with someone who you trust. Um,
So the next one is I have, and this is somebody that said, like, what if they just left it to the state? If they had properties in different states, which state would take precedence? Or would every state have to deal with it differently, making it even more expensive?
yes.
It goes through
Uh,
each individual state. So if
so
you're
what your primary probate will be in the state where you're domiciled or where you reside. And then if you own real property in your name in other states, you will probably have to do an ancillary probate in each of those states.
Next one I have, top of the Q&A box says, in a trust, can you require someone to finish college before they receive the money or request something similar that's considered reasonable?
Yes, you can. I don't know whether or not there are, you know, a trust can have limitations and set certain parameters for when distributions can be made and should be made. Beneficiaries can contest those. Every state is going to be different. Every legal system is different. There are definitely situations where beneficiaries have challenged the validity of a trust and taken the trustee to court to try and get assets. And again, each state is going to have different laws, different precedents for, for resolving those disputes.
So the next one, and I'm going to pull one from the Q&A and one from the chat box because they are partially related, is does having a trust automatically make you eligible for the federal tax exemption? And any clarity on that? And the other one coming from the chat box is more about wills. It says, like, even if you have a will in place, if you have a certain amount of assets, is there any chance that could still go through probate, or would a will get out of probate too?
So a will won't get you out of probate. A will keep you in probate. A will is part of the assets that are in your own name will pass through the probate process, but will be administered and distributed pursuant to the terms of your will. With regard to automatically being eligible for the federal tax exemption, every U.S. citizen is eligible for the federal tax exemption. That is, you don't have to apply for it. It's what you are entitled to. Anything above that exemption amount, wherever it is subject to estate tax.
So the next one, this is coming back from the chat box again. If somebody thinks they have a trust, but they can't remember, is there any way to figure that out?
What stays out of the trust? Is that the question?
No, they say, is there a way to determine if someone has a trust if they think they have one but can't remember?
Are we talking about a revocable trust? If they're talking about yes and no. A revocable trust, if you created a revocable trust and you don't know about it, then no one else is necessarily going to know about it. You may want to speak to the attorney who you think may have drafted it. More complicated is a situation where perhaps there was an irrevocable trust created, and you don't know about it. And again, that gets very complicated. There may be ways of tracking down an irrevocable trust through a tax ID number and the IRS. But that's not going to be an easy process. But again, it goes to my point that keeping your records someplace accessible and making sure you know where your documents are and your family members know where your documents are is important.
Yeah.
The next one, this goes to taxes. I mean, how often are estates taxed?
At the time of death, is when the estate taxes are filed in that year. Is the easy way to answer it. So it occurs one time, and that's at death. Now, if, like we said before, if there's a married couple and the first spouse passes, there's probably no estate taxes due then. That would occur when the second spouse passes.
The next one is I currently have a trust with instructions to my children, this one specifically daughters, to sell all assets upon our death. How hard is it for them to sell our assets and distribute to siblings and grandkids? And who do they reach out to handle those plans?
That's going to be dependent on the assets in the trust. I mean, if you have real estate or if you have a business interest in the trust, that's going to be a lot more harder to sell because they're not as liquid. If we're talking about cash, stocks, cars, those might be easier to sell. It's really going to be dependent on what's in the trust.
Absolutely. And it will be the responsibility of the trustee to administer that trust. So they'll be responsible and, for administering it and following those directives.
The next one I have is if you're going to be living primarily overseas, how does this affect how you might set up a trust?
Again, it depends on where you're going to be living. If you're going to be there full time, if you're going to continue to have, domicile somewhere here. Estate planning for cross-border issues is it's another world completely, multiple worlds depending on where you're going to be. So, you need to speak to an attorney, and if you're living permanently somewhere else, you need to look at the laws of that country as well.
So this next one, I feel like the answer is just whatever you want, but your choice. What's the proper contingent beneficiary for retirement accounts? Would you put, is your recommendation your children's names or the trust?
That is a tough one to answer without knowing the person's wishes and wants. So you definitely need to talk with an attorney. I hate to say it, but a lot of answers on this is just it depends, and it depends on what you want to do. Determines how we kind of answer that. In general, if you're looking for safety and the most control beyond the grave, then naming the trust is the better way to go. If you have adult kids that are married and you like them and you like their spouses and they're non-community property states, then maybe just giving to them outright makes most sense. We would need more information to better answer that, I think.
Absolutely. And it gets complicated, especially with Secure 2.0 in terms of making sure the trust and the beneficiaries of the trust are properly titled, so as not to compromise the 10-year stretch out rule for beneficiaries, et cetera. So really does need further consideration. There's no easy answer there.
I think we semi-addressed this, but I still do actually have a couple questions on it. I think it goes to elder care. Any tips on kind of protecting property and assets against your nursing home expenses? And just maybe how do people go about doing that, since you kind of mentioned it's a little bit different from the regular trust?
That is a whole separate webinar that maybe we should add and discuss in the future. But when we're doing that, you need to work with an elder care attorney. Please feel free to reach out to us if you need some names in your state. And it's all based around planning for Medicare, Medi-Cal to avoid, Medicaid, good Lord. It's Medi-Cal in California, which is actually Medicaid. But essentially that's where you're having the government or the state step in and pay for the things. So the assets are being protected for the heirs and for the surviving spouse. It can be done, but it needs to be done with an elder planning attorney.
And it's important to recognize that the government will have a 5-year look back rule for any assets transferred. So again, it has to be very carefully structured. Needless to say, the government wants, it has to be carefully structured and set up in such a way so as not to compromise assets moving forward.
So next one I have here is, can I be the trustee of an irrevocable trust for my adult children?
And the answer is it depends. In terms of certain guidelines, yes, technically you can be, but in terms of distributions made to them, it's probably not the best idea, and certainly not if you were the grantor of that trust. So it depends on the situation and the terms of the trust.
Got it. So what is next one I have is like any good resource guide for vetting a CFP or an estate planning attorney, like any specific standards, professional guidelines that we should emphasize? I mean, I think like CFP board, maybe website and stuff like that.
CFP board is good. If you're looking for a CFP, we have a selection checklist. So just email us. We're happy to send that out to you. If it's looking for an estate planning attorney, Kara, what's the designation you typically look for on that?
Well, it depends. I mean, you could look for somebody who's an ACTEC fellow, but it may or may not be necessary. That is one certification. Obviously, I would review their bar status, make sure there are no complaints against them, make sure that they're up to date, and really talk to references. We do a lot of referring to estate planning attorneys, and a lot of it is based on who clients have worked with or who advisors have worked with over the years.
So the next one I have here is somebody that is getting married soon. Would it make sense to set up a living trust right afterwards? They're also thinking about like having some kind of prenuptial agreement. Do estate lawyers usually handle those types of agreements as well?
Frequently they do. Lots of times estate planning attorneys will also work on prenups. They're also sometimes handled by family law attorneys. But yes, it's important to have that prenup in place before, rather than trying to do it as a postnuptial agreement, if that's something that you're contemplating. And then when you do a estate plan, make sure that the estate plan you put in place is compliant with the terms of the premarital agreement that you've entered into.
The next one I have is for an irrevocable trust. What is a trust protector? And is that needed?
So a trust protector is somebody put into an irrevocable trust who's given certain powers to make changes to the trust. Sometimes they're given the power to remove and replace the trustee, or other specific powers within the trust. And not to get complicated, if it's a grantor trust, sometimes they have the power to turn off that grantor trust status, etc. With an irrevocable trust, it is, as its name suggests, not revocable. So it is in place, and while certain changes can be made, a trust protector is usually somebody appointed in that document to make those changes within certain limitations.
And so this is one that actually came from a question much earlier about being a community property estate, and can you create a separate will and trust from your spouse for prior assets and inherited assets? And they wanted to clarify, like, if it was specifically to leave it to your children instead of your spouse. Like, and that again is to prior and inherited assets exclusively.
You can do that, but in a community property estate, the spouse has a 50% right to those assets, so they may still have the right to go to court and put a claim on the half of those assets.
Yep. So next question I have here, do you have any suggestions, this maybe depends on the family, on choosing executors for a trust, and any pros and cons of choosing adult children who, at least today, seem to have a good relationship with each other?
So go ahead, Paul.
Okay. Choosing a trust executor or trustee can be very challenging. Oftentimes you want it to be someone that has that's detail oriented and has strong financial acumen, because there's things that are going to have to be done, like possibly filing of tax returns for the trust, for example. So you're going to want someone that can do that. Naming family members is fine if there's a good, healthy relationship and there's not conflicts of interest. If one of the kids is a trustee and there's a conflict of interest where they might make decisions that benefit them, not everyone else, that can create problems. A lot of times it can be good just to have a independent third party, where I've seen, best friends, aunts, uncles named, just to reduce the potential friction between the kids.
Agree. I think it depends on any specific situation.
Yeah, I think money makes people do some weird things. The best relationships I've seen torn apart when grandparents and parents have passed. Okay, next question. This goes to IRAs. I mean, do you recommend that the IRAs and 401ks and 403bs, et cetera, go to like either trust, revocable or irrevocable trust? Like,
a lot of times they will stay outside of the trust, especially if there's not any estate tax considerations. The one time where I see this typically being broken, or where the retirement accounts like IRAs and 401ks do go inside a trust, is if there's minor children. Now, that's not 100% of the time. That's just kind of some generalities of what I've seen. Carol, how about yourself?
Again, it really depends on the specific situations. And again, with Secure 2.0, the rules regarding designating beneficiaries under the trust have to be very clear, need to be specific. If you just leave, for example, if you just leave it to the revocable trust and the remainder beneficiaries of that trust include a charity, let's say, it could compromise the 10-year stretch out for the individual beneficiaries. So if you are leaving those assets, if you're naming the trust as the beneficiary, I would be specific perhaps about the trust for each kid under that trust, or just making sure that the trust is properly drafted, that you won't have complications.
awesome. Next one I have here, and this is coming back from the chat box, instead of the Q&A. If a trust was created and a house was sold, and the person passed without having updated the trust, what happens next? I'm assuming maybe probate.
I'm not sure I understand the question. Repeat it.
I think somebody had created a trust, and a house was sold. The person passes, but hadn't updated the house, maybe to include the assets of the house.
If I'm understanding this correctly, it sounds like the trust was updated so that the house was supposed to be included in the trust, but
it was not updated to include the house.
But the deed wasn't changed, so the house should have been the name of the trust when it was sold, but it wasn't. I think you can petition that at this to get that added to the trust, but there's no guarantee that that's going to work by any means.
My guess is the courts are going to require, in Florida, the courts would require that real estate to be probated. So again, it really depends. Every state is different. Every county with regard to real estate is actually different. But if the real property is entitled in the name of the trust, under any circumstance, I would think would have to go through some probate process even to move it into the trust.
House was included in the trust. House was sold during that time, but the trust was never updated. I think we got some clarification there. But
I would think it's good. I mean, the assets in the trust are going to be, administered pursuant to the terms of the trust. If there was,
Okay, so I got the next one. I'm going to do two together because they're the same. One is, one person's moving from, they have a revocable trust in California. They're moving to Pennsylvania. I have another one. Just what if you just move residents from one state to another? Is your original trust still valid in the new state, or would you want to terminate it and redo?
Always update it for the new state that you live in.
Absolutely.
Okay, so I'm gonna give you like 3 more, so we can try to wrap this thing up. I know we're coming up on like 15 minutes after where we build this thing, Kara. I see your note too. Next one that I have, is it possible to limit assets inherited by your beneficiary without passing down to the beneficiary's like stepchildren?
You can, in a trust, you can provide that assets are held in trust for their benefit and then go to other people after their death. You can have flexibility as to who the remainder beneficiaries are. I'm not exactly sure if that answers the question.
Next one, I had a revocable trust years ago. My new husband and I recently created a new revocable trust. Do I need to formally terminate the old trust?
So usually when you create a new revocable trust, you are amending and restating the old trust, and it will specifically say that this is an amended and restated trust that replaces the prior trust. If that wasn't done and it doesn't reference the older trust, you could possibly create, I would consider having some document that references the older trust and revokes it so that there's no question when you pass away as to, again, how the assets are to be administered.
And then that's the last one. I know we just got a couple other questions, but since we need to do call time out of respect for Kara's time, Paul, if you do see that one that just came in, maybe you could type in the answer real quick. But when is generation skipping a good idea?
So generation skipping is, again, a good idea. It depends on every individual's own needs, wants, etc. Generation skipping trust is a trust in addition to, and we're not going to get into this, but in addition to federal estate taxes, there are generation skipping transfer taxes applied at later gifts to later generations. So the GST exemption is the same as the federal exemption. So for the first $13.6 million of a trust or of your assets, you apply GST to it. And so it is also exempt from generation skipping transfer tax. In terms of the idea of skipping a generation in terms of leaving your assets, if you don't want to leave them to your kids and just leave them to your grandkids, well, that's a conversation that you and your family can have. There are situations where it may make sense for lots of different reasons, but that's, again, more of a personal decision.
Yep. Awesome. Thanks so much, Kara. Paul is typing actually a couple of answers to the last couple of questions in there, so we can wrap this up and be respectful of Kara's time.
No, it's not a problem. I didn't know how long this was scheduled to continue.
I mean, the last one we have that Paul's not typing is, I mean, do you have any advice, or is there ways to find property in someone's name? Their mental capacity is deteriorating, and it seems like they might have had a lot of different policies and homes and whatnot. Is there any way to try to figure that out?
Again, this goes to my stress throughout this entire conversation, which is please keep your records in a way that your loved ones will find them later on, because it does become complicated. If you have a loved one who is, where you don't think they necessarily know what's going on, go through their records to the extent you're comfortable invading their privacy to see what's there. If you know the names of their attorney, their financial planner, their life insurance agent, reach out to them.
Other than that, I would just add, there is a way to check. Every state has a website for what's called the money that's been escheated. So maybe they were supposed to get a check for something and they moved. Old stock positions, things like that might be listed there. So just type in escheated or missing property in the state you live in, and you should find a link to the website to look it up. You can just look it up by the person's name. Otherwise, things like homes, that is public records. So just start searching where they might have lived or where they might have bought the property. You might be able to find some stuff that way, but that's finding a needle in a haystack.
Awesome. That's the last one. You too, Kara. Thanks so much for staying on, especially an extra, nearly 20 minutes after our close time. I think everybody here loves it. We can stay on and answer questions and get through them. Paul, thanks for all your expertise too. Thanks for giving me that disclosure so compliance doesn't bite my head off afterwards as well. And for all of you still on the line, thanks so much for attending today. We hope you all found this information valuable and useful as you plan for the rest of your lives. Thanks everyone. We hope you have a great afternoon.
Thank you. Thanks for having me.